Hi, welcome to Real Charlotte Living, a podcast about Charlotte area lifestyle, real estate, and business. I'm your host, Kamilah Peebles Brathwaite, and on today's episode, we are going to talk about the buyer agency agreement in North Carolina. This is important for me to share because of a couple of reasons. For many of you, you have never purchased a home, or it's been years since the last time you purchased a home, or you're relocating from another country, another state, and you're not familiar with the laws in North Carolina as it relates to buying real estate. So today, I want to help you have a little better understanding of that process, because for me, when I have an informed buyer, I have a better buyer. So I hope today's episode is helpful to you. The first document that we will review is called the Working with Real Estate Agents brochure or disclosure. It is a required document in North Carolina. It is not a contract, okay? It is not a contract. So you may encounter agents who review this and ask you to sign it, but you're not engaged in a contract with them. And the reason that this form exists is the state of North Carolina felt it was important that buyers understood their relationship with real estate agents. And so there are a couple of ways that you can do business with an agent. You are either a client or a customer. You're always a customer until the point you have a signed buyer agency agreement. At that point, you become a client. The other important note for the Working with Real Estate Agents brochure is in North Carolina, we are allowed to conduct what is called dual agency. Dual agency is a relationship, to summarize, we're able to work both sides of the deal. For dual agency to occur, it can happen in two different ways. So let's say, for example, you hire me and I'm affiliated with a particular firm. That firm has lots of agents. So let's say you hire me to represent you as the buyer, but you fall in love with a house that's represented by another agent in our firm. At that point, you will be entering into dual agency because the firm is representing both sides of the deal. Another example of dual agency is, for example, you're hiring me as your buyer agent. We find a home, let's say the seller does not have an agent and has asked me to represent them as well. In that case, I am allowed to represent both the buyer and the seller. In that case, we would have to limit the areas of expertise that I can share with you. So that's one of the challenges of dual agency, is I would then be limited to how much information I could share with you. My role as your advisor is now limited to just providing instructions on how to fill out forms. Now, we're not stuck with just that form of dual agency. We have what's called designated dual agency. And in my professional opinion, it is the better form of dual agency that is an option in North Carolina. Designated dual agency means, for example, I'm representing you as the buyer. You fall in love with another home that my firm has listed, and another agent is representing that. The firm can have us operate as designated dual agents. In that way, I wholly represent your interests, and the agent representing the seller wholly represents their interests. In that regard, we're both able to advise and consult our clients individually without sharing or compromising confidential information for either party, if that makes sense. The other side of that is, let's say you are my buyer and we find a home, the seller doesn't have an agent. I would advise that seller to go get an agent, or maybe give them a list of options to choose from so that they have their own representation and you still have yours. So in a nutshell, that is the working with real estate agents disclosure. They want to make sure that you know that until you've actually entered into a buyer agency agreement with an agent, you are not a client, you're only a customer, and there is no duty to maintain confidentiality. That's one of the key pieces, is once you have signed that buyer agency agreement, that binds us as agents to a duty to you, to protect you, to advise you, and consult you, and keep all of your information confidential. So now let's go into the actual buyer agency agreement. Now, the first section, if you've signed any kind of contract, it'll be very familiar. So it's going to identify who the contract is with. So you're going to have the parties are going to be yourself, and then typically you're hiring the firm, not an individual. In North Carolina, you're going to be hiring a firm. Now, it could be a very large firm, it could be a small firm, it could be someone has started their own firm. But when you enter that agreement, you are entering an agreement between yourself and between the firm. And when you're hiring, let's say me, for example, Kamilah Peebles Brathwaite, if you're hiring me to represent you, you're hiring the firm and you're hiring me as your representative, if that makes sense. So the first item is that we are going to specify what services are going to be provided. Those services are going to outline just a general idea of what you're looking for, what areas you're looking in. Maybe you know and maybe you don't know. So usually that area can be like, for example, I'm in Charlotte, North Carolina primarily. I'm also licensed in South Carolina. But if you're looking in the north, in this region, I'll say Charlotte, Mecklenburg, and surrounding counties. And that kind of covers if you want to wander into Union County and other areas as well. The next section is buyer disclosures. And here we are going to confirm that you are not already in a relationship with another agent, that you have the ability to sign an agreement with me, and also that you're not working with a relocation company, because if you are, there are certain processes and probably other parties that need to be involved before you can sign a buyer agency agreement. The next section is the terms of the agreement, and this is just going to outline when we're starting, when we're ending. So in North Carolina, our contracts become effective once all parties have signed. And then we typically will put an end date, and it's whatever, it's different for different people. So there is no standard there. And sometimes it's different for your situation. For example, if you're buying new construction, that process usually takes a lot longer than someone buying a new home, so the buyer agency agreement will accommodate for that. The next section is the fee for services. So we are professionals. We do charge a fee for our services just like anyone else. And so this is going to outline how those fees are paid. So there are a couple of different options. You can some firms or agents can charge a non-refundable retainer fee. And this is, I think the best example is attorneys. They do this all the time. So let's say you have an attorney you work with on a regular basis. They're charging you for services every month because you continually need these services. Usually I see the non-refundable retainers displayed with investors who are constantly purchasing properties over and over, or constantly needing you to be on the look for them for long periods of time. Another option is the percent of gross sales. And this percent is flexible depending on, again, the agent and the firm that you're working with. And it's negotiable just like any other thing. So That's another option. And then there's a flat fee. That's a third option. And then there's a fourth place to just make up what you want. Typically in North Carolina, I think you'll find the first two are usually what you're going to encounter. But again, it just depends on who you're working with. So how are those fees earned? When are they due and payable? Well, here the fee is due and payable when we have found a home for you. When you've actually gone under contract on something, then you pay the fee and it's due at closing. So it's not paid up front unless it's a retainer, because those are ongoing fees. But if you're doing, for example, a % of the sales price, then it's gonna be after you have gone under contract on a property and you have made it to the closing table, which is exciting. The seller or listing firm assistance, we may, as agents or firms, seek compensation for you as the buyer from the seller. Oftentimes, sellers will offer that as it's a marketing tool. It's something to help make their property more desirable, to give them a competitive advantage. So if that's something that we're offering, we'll seek that compensation from another firm, but it's not guaranteed. There's also a mutual termination is required. So let's say, for example, we're not working well, or maybe circumstances have changed for you, and you no longer want to buy a house, then all you have to do is submit that in writing, and we're able to terminate the agreement. However, if you don't terminate the agreement and you move on to another agent and go under contract with them, you would still owe our firm or the agent that you signed a buyer agency agreement with initially, you would still owe them compensation. So just make sure you work everything out. And I would advise you, if you're not happy with your service, talk to your agent, give them a chance to remedy the situation. I know I would appreciate that, and I think I can speak on behalf of others that they would appreciate that too. Okay, so then we have the protection period. The protection period means, and the best way I can describe this is to give you an example. And this is when let's say we have a buyer agency agreement, it's for 6 months. And in month 7, so at the end of 6 months, our agreement has expired. In month 7, you decide to go and purchase a home that you saw with the agent between months 1 and 6. Well, if we have the protection period in place for, let's say, 60 days after the expiration of the contract, the agent would still be due their compensation because they showed you that home and they are due that compensation because you went under contract within that protection period. And this was really designed to protect, honestly, us as professionals from people who were wanting to do behind the back deals and to work, I would say, unethically and dishonestly. And that's not you, so we don't have to worry about that. North Carolina wants to make sure that everyone understands that the fee for services is negotiable. There is no set buyer agency fee. It's just like if you are going to have a plumber come to your house or you're going to get an oil change. I think that's a great example. Let's say you're going to get an oil change. You could go to one company and they have one price. You go to another company, they have a different price, or maybe someone's having a special. It's the same thing with real estate. So different brokers, different agents, different firms are going to have different prices. So it's up to you to decide what you're looking for, what you value, and to determine what you're getting for your money. Because that's, I always say, nothing is free. And if it is, I would ask why. The next section of the buyer agency agreement is dual agency. So it's going back over, this was so important that they have a separate disclosure form for it, and now it shows back up in the buyer agency agreement. And again, they just want to remind you what dual agency is, when it occurs. As an agent, I have the responsibility to inform you anytime that you enter into dual agency if you're not already aware. So it's my job to make sure that you know that you're in dual agency. And then if we are, for example, going to remain in our standard dual agency, not designated, so if you're going to have myself represent both you and the seller, we have to agree to that in writing, okay? So it never just will happen. It has to be something that we talk about, explain, you understand the risks that are involved with that, and you are accepting or rejecting that. Let's see, material facts. Even under dual agency, I know we talked about, I can't really advise you, but I still have a duty to disclose what's considered a material fact. Anything that is significant information that I have knowledge of, I'm required to share that with you. So that part you can kind of be at ease about. The other thing to consider when in dual agency, you are waiving a lot of rights. You're waiving rights to damages and claims and losses other than violations of the North Carolina real estate law. So again, they've said it twice, so it's important that you understand it. Something that's become, I would say, really prevalent within the last, 5 to 7 years has been the presence of surveillance. Everywhere you go, there's cameras. They've got cameras inside, they have cameras outside, the Ring doorbell. So in the buyer agency agreement, there's a statement here that just makes you aware, that says that you understand that this exists. The sellers are not supposed to be recording audio. But the one thing that I point out and try to remind people is even if the cameras on the inside are not recording audio, that Ring doorbell or Nest or whatever smart doorbell is there, it's recording audio. So don't talk at the front door, wait till we get back in the car, wait till we're at another location. But don't speak in front of the door because they are listening. And I have worked with enough sellers to know that they're listening. Other professional advice. So that's the next section. I am a real estate advisor. I am an expert in real estate. I study it. I practice it every day. I invest a lot of time and energy perfecting my craft, becoming better for my clients. I don't know anything about taxes. I don't build houses for a living. So there are going to be times where you have questions that I'm unable to answer because it's outside my area of expertise. So at that time, I'm going to refer you to someone who does know. So this is just another statement, just letting you know, I don't know everything. I don't even know everything about real estate. What I don't know there, I'll go get you an answer. And if you ask me a question about another profession, I'll find you another professional. Inspection costs. That's another, I think sometimes buyers forget about the extra cost of purchasing a home. So when you find the home of your dreams, we are going to want to do inspections and a couple other series of things to help make sure this is not only what appears to be your dream home, but also is a sound purchase. And so one of those things is going to be inspections, and that is your responsibility as the buyer to pay, are the inspection costs. Now we're getting down towards the end. This document used to be 7 pages. It's now 3. I'm very excited, and you should be too. A couple of the last items are important. We have confidentiality. I have a duty to keep any information you share with me, the price or other terms of an offer That's between you and I and, the seller and the listing agent that we're submitting that offer to. I cannot go running around talking about those things with other people because you never know who's listening and maybe they're interested in buying that home. And so that's why it's important that we as agents, or whoever you choose to engage with as your buyer agent, that they're keeping your information confidential. Almost at the end is wire fraud. This is very, very serious. People are losing hundreds of thousands of dollars, if not millions, because they are not taking the time to double check and make sure that the wiring instructions that they have are accurate. So we have big red letter warnings. I tell my clients, don't send a wire until you've talked to me. Don't send a wire until you've talked to the attorney's office. Don't send a wire until you've talked to the bank. Like 3 times, I want to be able to remind you that you need to check with the attorney's office again, you need to check with your bank again, so that we have these extra stops in place, because I don't want to see you being taken advantage of. And the criminals have gotten very, very savvy. So just remember, wire fraud, it's a real thing, and to be on high alert at all times. Wrapping things up here, we have just a couple of statements about the agreement is all of the pages that are included. So all 3 pages constitute this agreement. If there are challenges and we, for some reason, I won't say we, because we should get along if you work with me, but let's say you're not getting along with your agent and there's a conflict and it needs a legal solution, you're going to agree to mediation first. And then the final statement is the non-discrimination statement. I say in North Carolina, we are required as agents to bring a ready, willing, and able buyer. Outside of that, nothing else matters. Not your skin, not your religion, nothing else matters. Are you ready, willing, and able? And part of that ability, that able part, is are you pre-approved? Are you financially able to purchase a home? And so that is information that we do have to verify. But other than that, we shouldn't be caring about any other details. Finally, we have our signatures. And again, as I said in the beginning, the agreement takes effect once all parties have signed. This is the buyer agency agreement in North Carolina. I'm Kamilah Peebles Brathwaite, your host at Real Charlotte Living. I hope you found this information helpful. If you have questions, please don't hesitate to reach out. My information is at the end of the video. It's on my website. I'm very easy to get a hold of, and I'm always happy to help you. Thank you and have a great day.